time, publicly, to address a problem. Email I'm sending out. Here's some of a previous email. Dakota County wanted to act like they didn't block me from sending emails. These failure notices, those are all blocked messages. Due to my continuous threats of litigation, that they're going to cut all communication. There's no threats. There's no litigation threats. This is how they choose to decide to deal with the problem. Since 2021 till now. It took them this long to come up with something like that and to mail out an email like this saying that. This guy's got court orders, no contact with children, except for his own supervised, which is supposed to be set up with the mother. How is he trying to file papers in Scott County to try and get unsupervised contact with, at this point, it would have been my 5-year-old daughter, and I was never even aware of it. The letter probation sent in regards to him trying to file that, admitting in their own words that they've been allowing him to have contact with my minor daughter. It was never written or worded or approved at all for a PO to have consent to even allow him to have supervised contact with any other children. He was court ordered only with his own children. That was it. Right here, they had concerns about wanting my daughter to go to a good touch, bad touch program to evaluate the situation. None of this was done. They didn't do anything. No child mandate report, no child protection, no nothing. Nothing. Judge grants motion to lift no contact is not granted. No contact means no contact. It don't say per PO approval. It don't say approval with PO or can have supervised contact with other children. Motion to lift no contact is not granted. The judge ordered this May of 2008. Literally 3 months later, they buy a house and they're living together. If a judge just ordered this 3 months prior, no contact means no contact, why in the hell was Dakota County probation officers allowing him to purchase a house with a minor child living under the same roof? They didn't do no child mandate report. They didn't notify child protection. They didn't even notify the South St. Paul Police Department. They did nothing. But they most definitely did file papers after I contacted his PO, after I found out and started calling about my concerns and questioning it. She didn't do anything, didn't do no investigation, didn't do nothing at all whatsoever. But what she did do is file papers on trying to get him released from probation. How does a convicted child molester who was molesting his own child for over a year, his 4-year-old daughter with adult sex toys, for over a year, not be on no sex offender registry, never went to prison, went to jail for like 6 months with work release, had contact with his children, not only that, my minor child the whole time, was able to take my minor child out of state on vacation numerous times when he has court orders, no contact with children. Never ever was I contacted, informed, or anything whatsoever. And you call this a legal system? You call this probation officers overseeing convicted child molesters? Sick, fucking perverted pedophile. Far left is my minor daughter. And there's his 2 minor kids too. Back in early 2005, 2006. What kind of sick mother would actually put their minor child like that around a pedophile and knowing he was a pedophile all along? Started dating him before he even pled guilty to molesting his own child, and would actually go and apply and file court papers in Scott County to try and get this pedophile to have unsupervised contact with their own minor child. What kind of sick mother would do that? So many questions, 0 answers.